Good morning to all of you. Andarki Shubhodayam. Welcome to Legal Matters by Sai Babu Sukra. Honorable Supreme Court of India actually reprimanded High Court Judge, Rajasthan High Court Judge, for not assessing whether the convict has got a fair chance of acquittal before suspending the sentence under section 389 crpc, suspension of sentence. Justice Madam B.V. Nagaratna and K.V. Vishwanathan of the Supreme Court of India in the case of Jamnalal versus State of Rajasthan and another SLP number 691 by 2025 on 6th, that is the day before yesterday, మాకైతే నిన్నే 6/8/2025 noted that the High Court of Rajasthan failed to assess whether the convict has a faint chance of acquittal or conviction before granting him bail and before suspending of sentence under section 389 CRPC. So friends, we all know suspension of sentence will be given automatically and most likely, generally, automatically in cases where the punishment is less than 3 years. ఒక కేసులో ముద్దాయికి 3 years punishment ఇస్తే then judge himself has to tell that you have got a right to appeal and you can get it suspended. ఇమీడియట్గా లాయర్లుగా మనం సస్పెన్షన్ ఆఫ్ సెంటెన్స్ వేస్తాం, బెయిల్ కూడా తీసుకుంటాం. కానీ పెద్ద పెద్ద కేసుల్లో వేస్తే జడ్జి గారు చూడాలిగా అసలు ఈ కేసు ఉండే కేసా పోయే కేసా అనేటువంటి చూసుకోకుండా బెయిల్ ఇస్తే వచ్చే ప్రాబ్లం ఏంటి అనే దాని గురించి సుప్రీంకోర్టు వారు చాలా సీరియస్గా చెప్పారు. రైట్, నౌ కమింగ్ టు ద ఫ్యాక్ట్స్ ఆఫ్ ద కేస్. ఈ తక్కువ కేసు కదా, పోక్సో ప్లస్ 376 పోక్సో అండ్ రేప్. On 13/6/2023 at about 4 p.m. when the victim and the case complainant went to the fields to defecate, సహజంగా చెంబులు పట్టుకుని సాయంత్రం పూట ఊళ్ళో వెళ్తూ ఉంటాం పల్లెటూరులో, ఇప్పుడు లేదు కానీ లెట్రిన్లు వచ్చినా అంతకుముందు ఇదే పని. when she went to the outside fields for defecation, then the accused came behind her and he threatened her at gunpoint, took her to the nearby dry land. అక్కడ ఒక చావిడి ఉంది, షెడ్ ఉంది. there he committed rape on her at gunpoint. Then she came back, informed the mother, who informed the father. Immediately they went to the police station and reported the matter. Since she has not completed, she is just 14 or 15 years old. She has not completed 18 years. She was taken as a child under section 2D of the POCSO Act. Therefore, aggravated sexual penalty section 3 and 4 of the POCSO Act as well as section 376 of the Indian Penal Code were registered. So FIR was registered against him under section 3 and 4 of the POCSO Act, section 376 clause 3 of the IPC. Right, now the matter, of course the trial went on. ట్రయల్లో మిస్టేక్స్ మీరు చూడండి. ట్రయల్లో మెడికల్ రిపోర్ట్ ఎప్పుడు అలాగే ఉంటుంది, ఇది అయిందా కాదా చెప్పదు. బికాస్ మెడికల్ రిపోర్ట్ ఇంపార్టెంట్ పాయింట్ చెప్తాను అయింది కానీ. No external injury was found on genitalia or personality of the victim. Number 1. FSL report, no semen found. DNA report not produced. FSL నెగిటివ్ ఉంది, మెడికల్ ఒపీనియన్ కరెక్ట్గా లేదు, DNA రిపోర్ట్ ఫైల్ చేయలేదు. బట్ ఇన్ స్పైట్ ఆఫ్ దట్ ద కన్సర్న్ జడ్జ్, డిస్ట్రిక్ట్ జడ్జ్, he has taken or he has raised the presumption under section 29 and 30 of the POCSO Act. Very, very important. 29 and 30. Judges మనకు కన్విక్షన్ చేది ముద్దాయి కన్విక్షన్ చేది ఇదే సెక్షన్. అందుకే చెప్తుంటాం ఎవరైనా రాజీ పడండి లేకపోతే చాలా కష్టమైన కేసు అని. చూడండి ఇక్కడ ట్రయల్ కోర్ట్ ఈవెన్ దో, ప్లీజ్ రిమెంబర్, ఈవెన్ దో the DNA report was not produced, FSL not furnished, the medical report is not substantive or conclusive, but basing on the version of the prosecution witness supported by the other witnesses who have stood to the rigorous test of the cross-examination, and since there are no material contradictions, he has raised the presumption under 29 and 30 and presumed A committed the offense. Right, POCSO Act wala advantage idi. And he also held that suppose DNA report is there, suppose FSL, all of them are only corroborative in nature, they are not conclusive. You all know according to section 42 of the Evidence Act, it is an expert evidence, the evidence is only corroborative, it is not conclusive. So he believed the oral evidence of the witnesses and came to the conclusion that he committed the offense. Of course, the burden of proof lies on the accused. The accused could not prove the case, prove that he did not commit the offense. He could not convince the court beyond all reasonable doubt. Therefore, conviction was given, that to 20 years conviction was given to him. 20-year sentence. Then, now we appealed to the, we has come revision, they could go to High Court. High Court law for the suspension of sentence, appeal is till such time for the suspension of sentence and bail is there. High Court judge garu రాసినటువంటి రాతలు అది కొంచెం జాగ్రత్తగా. High Court said, please remember, there are no FSL and DNA reports. The medical certificate discloses that she did not receive any external injury. So there is doubt. Scientific evidence. Nowadays we are all believing in the scientific evidence, but that is lacking here. Oral evidence means they can give parrot-like version. So therefore, he has given suspension of sentence. He has granted bail. But Supreme Court said that in the very famous case of Prakash Sahni versus Jai Shankar Choudhary and others, 2023, for considering the case for suspension of sentence under 380 CRPC and keeping in mind the antecedents, then only the judge has to go for suspension. But High Court judge is not justified in simply taking that the scientific evidence is lacking. The trial court is correct because they have assessed it perfectly. Therefore, we are setting aside the orders of the High Court, and therefore the accused is directed to surrender to the nearest magistrate before the trial court, surrender to the trial court. Then the matter will take its own course in appeal. Very good decision, very important. Supreme Court is emphasizing that you have to look into the antecedent, you have to look into the nature of the case, you have to see whether the case, whether the accused is likely to get a chance of acquittal or conviction. Right? Good decision. And last law, మనకు కొంత చేదస్తం కూడా చూడాలి. ఏమంటే ఇంత ఎక్విట్లో కన్విక్షన్ తెలుసుద్దా, చూడంగానే అర్థం అవుద్దా? ఈ ప్రశ్న మీ అందరికీ, దీని మీద మీరు కామెంట్ చేయండి. ఎనీవే, సుప్రీం కోర్ట్ జడ్జ్మెంట్, ఇట్ ఇస్ ద లా ఆఫ్ ద ల్యాండ్, read the case law and enrich you at legal law. Thank you.